Nice to see everyone. Happy Friday. Nice to see you. I hope everyone had a great 4th of July and happy 250th America, right? God bless America. I remember when I was a kid, 200-year anniversary um, was much bigger. At least in my town, we painted everything red, white, and blue at the time when I was a kid. But 250th was nice. There was some funky weather, and obviously everyone knows there's funky politics going on in the U.S. right now. But still, at least in my opinion, greatest country on earth, and thank God for what we have here. Great to see everybody, and hope you're having a nice summer. Again, the weather's been kind of weird. These flash floodings and rain coming down for 15 minutes and stopping. I know the fourth floor of my office building here had a swimming pool on it, and we did not intend to have a swimming pool on it. And we've had people, it was so hot that they left their car windows open, and now they're turning into mushroom farms. And so the weather's been a little iffy. But good to see everyone. And let's see, first thing, as you know, not legal advice for educational purposes only. And if you need an attorney, go out and either hire us or hire some other attorney with an attorney agreement. Nothing will be kept confidential, and it's all in good fun. And so I have gotten some requests for topics recently, which is great. I haven't reached them yet. I was going to do this one on the American flag, because we're so close to 4th of July. But this balcony solar thing came out, which is a little funky. So I wanted to get to that first. I also have some requests for doing a First Friday with Fran on social media, posting websites, all those fun and games where everyone wrote, they create a website that sounds a lot like the association's website, except that everything on it says, and the board sucks. So how we deal with that and how that works in our world and what the best way to deal with that is. So I am going to include those things as topics going forward in the next couple months. So, but as far as today is concerned, first, obviously, we can't skip this. And before we get to the dog of the day, I want to make sure that everyone knows we need dogs of the day. We're a little short on dogs of the day. So I think someone's going to have to go out there and adopt a dog because we also have to fill the 2027 calendar. Because remember, we take the dogs of the day from each month and then we make it for a calendar in the following calendar year. So we cannot skip dog of the day. So if anyone has a dog that hasn't been submitted, send the dog on in. If not, get out there and adopt a dog that is otherwise unwanted and send over a picture. So that would be great too. All right, so into let's go dog of the day then. Speaking of dog of the day, go Crystal. So today's dog of the day, I'm not seeing, there we go. Wow, looks very comfortable. That's a very happy dog right there, right? Very happy dog with the toy. So that's Dakota, and Dakota is, let's see, an Australian Labradoodle. I don't know what the difference between an Australian Labradoodle and a regular Labradoodle is, but very cute dog. And Dakota is owned by Dean Barber, who is the president and CEO of Executive Property Management. Executive Property Management has been around a very long time. They're based in central Jersey, but they cover the whole state. So thank you, Dean, for submitting the picture of your dog. And we'll get right into the Garden State Balcony Solar Act, which is Senate Bill 2368 from the current session. Just so you know, this has not been made law yet. Has not been made law yet. It has, however, been passed by the state legislature. That's why I wanted to kind of jump on it. And what does that mean? It is now on, you know this. So Mikey Sherrill, right? I hope you get that. There's Mikey Sherrill. Yes, no?
Yes, your pictures
Okay,
are
so that's
Mikey.
Mikey. Yeah, so that's the governor. That's the new governor. A lot of people haven't seen her very much yet, but she's a new governor. And this bill is going to the governor's desk because it has gotten through the Senate and the Assembly. And it has gotten through basically, I believe, without a single objection. Don't quote me on that. I think definitely in the Senate, it got through 40-0. And I believe there were no objections, no votes in the Assembly either. So I imagine Governor Sherrill will sign it, right? So that's why I wanted to jump on it today because it is going to be a little funky. Um, Sounds like a great idea, right? So what is it? So portable solar generation device defined. This is the definition of it under the act is 1200 watt max. So 1200 watt max, and I'm no electrician, I'm not a handyman. I can't turn a screw basically, but the it's 1200 watt max will run small appliances, will run um, kind of little things. They won't run, large things. They won't run things that require large amounts of watts to start up. Because keep in mind, and I'm again no electrician, there is starting power and then there is running power, right? So even though something may say it only takes a bit of power to run, it often takes a lot more power to actually start it and get it going. So keep in mind if you're getting into this stuff, that you make sure you're thinking about the right number of watts that you want to run something. So with 1200 watt max, designed to be connected through a standard 12-volt AC outlet. So that's that they call these plug and play systems, right? So the theory is you go out and put them on your deck or your patio, and you plug them into a wall, and they can help offset some of the crazy, insane charges we're paying to PSE&G and the other utilities right now with today's inflation rate in power, right? Uh, so obviously, this is a super hot topic across the country. These types of laws are being swept across the country, allowing for these type of plug and play solar panel systems. And a big part of that is because the energy costs have gone crazy, right? Especially electricity. Um, Located on the customer side of the electrical meter and intended primarily to supplement the customer's electricity consumption. So this is not people putting, fields of panels in their backyard and trying to flow electricity back into the electrical grid. This is aimed only at your own consumption, right? Only at your own consumption. So even if um, even if you're generating more electricity from your panels, um, then you're actually drawing down in your house. The intent of this act is not to put more power back into the grid. I don't know why that's exactly aimed at that way. Maybe there's additional electrical issues. Maybe it's just that the quasi monopolies that the power companies have don't want that to happen. I have no idea. I try to stay away from the conspiracy theorists, but so it's supposed to be for consumption in your home. Listed or certified by certain entities. So certain entities are usually things like Underwriters Laboratory, et cetera. It can't be just something somebody solders together. Includes a feature that prevents exporting power to the electrical system during power outage. So that's the weird part to me. The act itself actually says includes a feature that prevents exporting power to the electrical system during power outage. So again, it does not want this system putting power back into the general electrical grid. Um, it's a per dwelling cap of 1200. So even though the definition of the portable solar generation device has a 1200 cap, it's really a 1200 cap as to that system and as to that unit. So as you know, everyone tries to push the envelope. So you're going to have guys going out and say, well, it says $1,200, 1200 watt cap. I want to put in 3 systems on my balcony. The answer to that is no. The statute says it's a 1200 watt cap as to that device and also per unit, per dwelling unit, unless you go out and have an interconnection agreement with the utility that serves your community. So it wouldn't be the association going out and saying, hey, we don't care how many systems you have. They would actually have to go out and get an agreement, an interconnection agreement with the utility that serves your community. Association may not prohibit a unit owner or tenant from utilizing a portable solar generation device or placing a portable solar generation device on the exterior of the unit owner's or tenant's premises. This is going to be litigated, right? I mean, really, this should have been addressed, in my opinion, during the legislative process. But I think people were so agreeable to it, they haven't gotten out there and addressed it. Because especially the people in condos and co-ops, you know that in condos and co-ops, generally speaking, the patios and balconies are common elements or limited common elements, right? And so one could argue that um, it's not the exterior of the unit owner's or tenant's premises. It's actually the association's premises or the co-op's premises. But I think a court would probably look at this act and say, come on, friend, that's a ridiculous interpretation of the act, because if you have something called the Balcony Solar Act, how can you then take a position that nobody can put solar arrays on the balcony because it's not the tenants or the unit owners' premises? So I think the way that probably would be interpreted by a court is exclusive use areas, with respect to patios and balconies. So, and most patios and balconies are exclusive use areas. In some associations, especially mid-rises and certain high rises, they're not. You have balconies that are used by lots of people, and they're not limited common elements. It's purely common element, can be used by everyone in the community. I would say this act does not apply to that because I think it's a decent argument to say that's not the unit owners or the tenants' premises, right? It's not assigned to them. It's not limited to them. So you can't just run out there on a general common balcony and start putting up solar arrays. Association may establish reasonable restrictions concerning the size, placement, or manner of placement of a solar generation device on the exterior of the unit owners or tenants' premises. And I'm going to share screen again on that because, this was a bit of a surprise to me. Just so you know, I have not used one of these in my home yet, but it seems like a pretty cool idea. But this kind of surprised me when I started poking around and looking at them. Where are we? So can everyone see that? This is from YouTube. I don't know who this
Yes.
guy's. You got it. So this
Yes.
is Jason, somebody. He's a YouTuber. I'm not endorsing his product or his company or whatever it is, but this surprised me the way this was laid out, because I had imagined when I first saw this law that these would be folding panels set up on a tripod or something on the balcony itself. But no, it looks like people go ahead and attach them to the outside of the railing. I assume based on whatever gets the most sun, right? Unobstructed sun. And, you know, I wouldn't say it's the ugliest thing in the world, but it's certainly not the prettiest, right? Not the prettiest thing in the world. So especially depending on the color scheme of your community. So that is going to be, I think, hotly contested because, again, the provision says the association may establish reasonable restrictions concerning the size, placement, or manner of placement of a portable solar generation device on the exterior of the unit owner's or tenant's premises. I am not sure that a court would disallow this based on the it's ugly, right? Based on the it's ugly position. I don't think the court would say, hey, you know, uh, it's an aesthetic issue, so therefore you can't have it, or you must put it on a tripod inside the balcony itself. I'll stop share there for a second. Because I think that if the association were to go back, oh, hey, Kevin, haven't seen you. I like the hat. Um, the the It would block, right? So if we put a tripod back inside the patio or inside the balcony, it would block the sun, right? So I think a court would probably say that's not a reasonable restriction, friend. You may not like it there. It may not be the prettiest thing in the world, but it's unreasonable to say he must put it on a tripod inside his deck area because it defeats the purpose of having the equipment, right? So that will probably be litigated again. So there are two areas of potential litigation I see so far in this act, in the language in the act. So we're going to have to think about that. The third area, association may require a tenant, unit owner, occupant to indemnify the association for claims, damages, losses, or liabilities arising from the personal injury or property damage caused by the negligent installation, maintenance, or use of a portable solar generation device. So again, I'm going to share screen again. So this is a single family home. It may be a townhome. I can't tell if there's anything attached to the other side. But imagine this was a mid-rise in Hoboken, or God forbid, a high rise in Jersey City. And we have a nice windstorm like came through yesterday afternoon, and these things go flying, right? And it's raining solar panels in Jersey City, right? So that's scary. That's really scary, I think. And the question is, even though the law allows for the association to require that the unit owner or tenant indemnify, defend, and hold harmless the association, or at least indemnify. What assets does that homeowner have? And can the association require that homeowner or tenant to back that indemnification up with proof of homeowner's insurance? You see what I'm saying? Because it's one thing to agree to indemnify, but I could indemnify all of you, and if I have no assets, it's worthless, right? If I have a unit that's mortgaged up to the hilt and I have stacks of credit cards and somebody gets hurt or killed, God forbid, from one of these things flying off a building, the indemnification means nothing unless the indemnifier has assets or insurance. Stop share again. So that scared me a little bit, right? Because that exposes the associations, I believe, to liability. The next point I have is municipalities may not prohibit and may not require permits for placement or the use of portable solar generation devices. So this is important in a lot of associations because it depends on your community, but a place like Monroe Township, New Jersey, works pretty well hand in hand with associations. So if an association member goes to the township and says, hey, I want to do a modification of my unit or my home, in Monroe Township, at least the first thing the construction office will say, do you have the permission of the association? Right? Which is really helpful. And associations, to some degree, rely on that in Monroe. The municipalities cannot stop the project, right? It's basically the state saying, we want this stuff to happen, right? We want this stuff to happen. So don't rely on the township to stop it, because in some municipalities, the associations do. Some potential issues. I know we have a bunch of questions, and I will get to them shortly. But so some potential issues. The first one we talked about already. You know, the panels flying off the 25th floor and God forbid killing somebody on the ground. That's awful, right? We don't want that. And even if it's not killing anybody, but it lands on a car, it lands on the person below's deck. It just hurts people. It smashes other things. That's an issue, right? What about running cables through the siding or the walls or the sliders, and the water infiltration implications of running wires, right? So somebody has it on the patio, but they're taking a drill bit and drilling through your facade, right? Or drilling through the door frame, or running it under the slider insulation piece, right? On the bottom there. What's that doing to putting water into your building, right? Because as we know, water generally runs down, not all the time. Sometimes it wicks up, but it generally runs down with gravity. And are you rotting out things because somebody went and just drilled through your building? So that's an issue. Same thing, screws and other fasteners penetrating the building envelope, which is what we just talked about. The balcony floors, like, so if they're drilling down into the balcony floors, what's that doing? The railings, as you saw in that picture I showed you, are they screwing things into the railing? What is that doing to the railing? As to water infiltration and other damages. And I guess in line with that, can we make them, or should we make them remove them when ownership changes hands, right? So, you know, somebody moves in, like that guy I pictured, and he's a really responsible guy. He's all into solar systems and tech and all this other stuff, but he sells his unit and leaves it there. And the next unit owner is a knucklehead, and he doesn't maintain it, and there's loose panels and things are falling off and other stuff. So the question is, just because one owner puts it in, right, and agrees to indemnify, et cetera, what upon resale should we be doing? Should we be inspecting these systems? Should we be requiring them to be removed upon resale? The answer, unfortunately, for me right now is I don't know. I don't know if we can require that they be removed upon resale. Is there a fire risk? So the good news, I think, right now is that the theory under the law is as long as they're plug and play, people should not be wiring things into their panel, hardwiring things into their walls, messing with the association's electrical system. So I know many of you are in adult communities and you're in single family home, but we have a number of communities where, especially in conversions of mid-rises, or even high rises that were formerly apartments, the electrical system itself is a common system. So if some wacky person goes out there and starts trying to wire into the electrical system of the association, you do not want that, right? That's not what's supposed to happen here. This is supposed to be purely plug and play into an outlet. But as you know, people will push the envelope. And if you search any of this stuff on YouTube, there's a million ladies and guys out there giving you advice on how to install crazy solar systems. So I think all of us need to be aware that this is going to be on our radar really, really soon. Again, I talked about what is the unit owner's agreement to indemnify worth if it's not backed up by insurance. Who from the association, if anyone, will inspect the installation? So I would say if the association resident is going to put one of these systems in, that someone from the association should inspect it. The problem with that, though, is can they then make a claim that you inspected it and said it's good? Like we don't want to warrant that anything is good, right? We don't want to say, hey, it's cool, everything's great. So there's a double-edged sword with inspection, right? So be careful with that. Um, can the installation, right or wrong, negatively impact the association's wiring? So if you have a building, especially older buildings with older systems, older wiring systems, or common wiring systems, you're probably well served to have the association's engineer or electrician check the system if people start putting them in. Years ago, I had cases where um, associations were wired with pigtail wiring, where most of the building was copper wiring, but when they got down close to the outlets, they were switching to aluminum wiring that would then become loose and corroded, and it would become a fire risk because the separate metals would wind up corroding and arcing and starting fires. So if you have an association that you have any doubt regarding the wire system, please review it with the association's engineer and electrician. So that was really quick, but we do have some questions. I hope this is interesting to everyone. I know it seems a little mundane, but I think this is going to jump on our plate, in a whirlwind because people are really frustrated and I'm not just picking on PSE&G. As you know, the power everywhere has gotten crazy. They're really frustrated with the utility bills. Everyone's blaming it on data centers, right? But I don't know about that. I don't think it's all data centers. I think that's a lot of profit taking going on. Um, okay, Crystal put up there, please send your dogs. Oh yeah, so Barbara, I saw Barbara before. Where did Barbara go? Barbara's asking about cats. So we have nothing against cats. Yeah, there's Barbara. I can't see her. She got her camera off. I think Barbara might have been doing her hair earlier. Um, yeah, but we have nothing against cats. You can send it a cat. I just can't have them in the office because even though I really like cats, I'm allergic to them and I would stop breathing, which is so annoying. So annoying. Uh, so anyway, so we can definitely do cats in a day. So Barb, if you want to send your cat over, yeah, go for it. Um, I assume it does not have to be an HOA to approve. So Barbara asked, as this is individual, I assume there does not have to be an HOA approval. So the it's not necessarily an HOA approval process, Barbara. Um, but the association can require the indemnification agreement. So I would say that you should have HOA approval because, like I said, number one, you can require them to indemnify you, and number two, you can make reasonable restrictions with respect to, let's see, reasonable restrictions concerning the size, the placement, and the manner of placement, right? So even in HOA, I think um, you could make reasonable restrictions with respect to the size, placement, or manner of placement. Even though I can't imagine a whole bunch of restrictions in a single-family HOA community. Does this law affect condos as the roofs do not belong to the unit owners? So, Donna, I would say that the roofs are not unit owners or tenants' premises. The roofs in a condo association are not unit owners or tenants' premises. The prior act that concerned solar panels with respect to roofs in um, associations where the roofs were owned by the owners already allowed for those solar panels to be installed on the roofs. But especially in a condo association, the roofs are not tenants or owners' premises. So this is not aimed at allowing or requiring condos to put solar panel systems on the roofs in the common elements. Al says 1,200 watts is very low. Um, a fridge can take up to 800 watts to run, right? So yeah, Al's right. This is not, you're not going to run your own house on this. This is just a supplemental type thing. And there are all other types of systems, more powerful systems that you can do at greater expense. I'm told that these 1,200 watt systems, the most basic cheapo ones you can find are probably about 600 bucks. And the more expensive ones with battery backups and stuff could run about 2,500 bucks. So that's a wide range of product there. And you'd have to just see how much value you get out of it. But Al, thanks for that. You're not running your whole household for sure. Hopefully HOAs will be able to request a property modification request for each case, perhaps heading off by establishing architectural guidelines. Yeah, so I like that, Anna. Anna said, the association should require a modification request, and I think that's the right answer. You just can't go too far. And some boards, you'll be shocked to learn this, some boards go too far, right? And they want to put rules and regulations in place that really make people unable to do what the law requires, and then you're guaranteed to get litigation. And by the way, society, we represent Society Hill North in North Brunswick, which is a very nice community, and we have a board member there who's into this kind of stuff. So she raised this issue about this bill probably 2, 3, 4 months ago. So she was ahead of the curve. Um, Obviously, it hit my desk more urgently when it passed the legislature, especially so overwhelmingly a week or two ago. But more importantly, the day after it, it passed the legislature, guess what we had knocking on doors at Winfield and Somerset? Guys selling 1,200 watt solar systems, right? So all of us, all the managers, all the board members in the world can anticipate dealing with not only the 1,200 watt solar system issue, but also solicitation issues, right? Because you got these guys are now highly motivated to sell as many $2,500 systems if they can, obviously. And in addition, and I haven't gotten involved in this either, back when the bigger solar array systems came out, there were all these kinds of hokey leasing arrangements and chargeback rack sales and all this other nonsense. And many of those things were fraudulent, apparently. Um, but I think you're going to probably see that with this type of system too. People, you got to be careful, right? You don't want your homeowners exposed to nonsense. And there are people who will do, I think, leases on these types of systems and so forth and so on. So residents should be aware, especially of cold call solicitors on this type of stuff and door-to-door solicitors. And most all the associations that I work with have prohibitions on solicitation. So you might run into that. I've already run into it with Winfield over in Somerset. Um, and so we have to try and get ahead of that if we can. Um, but would it be disallowed based on HOA bylaws, common area unit uniformly? No. So Charlene says, hey, can't we disallow it based on the association's rules and regs and uniformity and so forth? The answer is no, and that's why this law came out. As it's funny, when I started working in this area in the early 90s, um, the judges and the legislature and everyone else didn't seem to know much about the community association field. And in a way, that was annoying, right? Because you'd go in front of a judge and you'd be like, Judge, this is the way they work. And she would not know really what's happening, or he would not really know what's happening. And in today's world, it seems like everyone knows about associations, and the legislature is turning it into a party and legislating the heck out of us, which is good and bad. So that can be good and bad. So we gotta be careful with that. So Charlene, the issue there is this preempts that type of stuff. Um, I can see this hindering emergency access to a unit. So Barb says it could hinder emergency access to unit, and it could, right? So it could. So I showed you that picture, and perhaps if that was in a mid-rise or something, a fire truck could not reach people. It would be more difficult to get over the railing, those types of things. And I unfortunately have been in not been in fires myself, but involved with fires at condo associations where people were rescued from the balconies, right? People were pulled off the balconies, and unfortunately, in that one case, someone died on her balcony. So that's a good point, and the association can take that into consideration. The only thing I would say there is if you're going to deny something based on hindering emergency access, I would have a written note, opinion, email, something from the first responder people, the emergency people, the fire people that says, hey, that proposal would make it very much more difficult for us to get in. And my experience has been with, especially with fire people, is they don't hesitate to destroy something to get in, right? So I imagine a first responder fire person would whack right through that stuff if he had to or she had to. So you got to be careful. You don't want it to sound like a pretext for denying the application, right? So if you're going to deny something based on that, make sure you have a basis for doing it, not just, I don't think this will help first responders, right? So be careful because that might be held arbitrary. Al says the systems shown are usually ones which recharge a self-contained battery system doing a direct feed. In my opinion, um, would cause an overload on the existing electrical system. So Al's saying, this could cause an overload on the electrical system. I don't know. Al has spent a lot more time in this type of stuff than I have. Al is a member over at Leisure Village West. And has been involved in this type of stuff for a long time. But so again, if you have a concern in your system regarding the age of the wiring, the type of the wiring, the type of the circuitry, the panel boards, etc., get an opinion from your association's electrician and or engineer to make sure that there is not a system. Ellen Kaminsky, hi Ellen, I didn't see you out there. Seems similar to what we went through in the satellite dishes. Yes, Ellen, yes, you are as old as I am. This was a big debate, right? This was a big debate a long time ago. Oh my gosh, the sky is falling. Everyone is going to put solar dishes. I'm sorry, yeah, satellite dishes on their walls and destroy everything. So yes, it's true, Ellen, that this is going to be a little funky because people will just try and get out there with a screw gun and be like zip, 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 and put it all through your siding and all this other nonsense. So be careful. This law does not mean that anything goes for sure. It gives the association um, the right, and probably the association has the obligation to make sure that it imposes reasonable restrictions. Al says again, mixing two different wires requires certain wire nuts designed for the same. Yeah, yeah. So in theory, none of this should be wiring things together. These systems that are referenced in here, they contemplate plug and play systems that are actually plugging into the outlet. So to the extent you see people in your association or they make proposals that that involve wiring with wire nuts and electrical tape and or nothing, bare wiring. People do crazy stuff. Um, they're going to create fire hazards and they have to be dealt with. And they don't, in my opinion, fall under this type of legislation. So if someone says, I'm going to do this, that, and the other thing, and their drawing says, hey, there's going to be wire nuts here and splices here and boxes here and etc. That's a whole different ball of wax that the association has to consider and has, in my opinion, the power to reject if it wants to. Um, Janet says, hey, I'm so stressed thinking of all the 200 condo owners trying to install this on their condo railings. Yeah, Janet, I know. It's like, what? So the other weird thing is, I know you're going to get this request too. My patio, balcony, you name it, is blocked by a tree. You need to cut the tree down so my solar panel gets sun. And I don't think in any way this law suggests that. You don't, I don't think the association should be in the position of taking trees down and things like that. But I'm sure somebody is going to come with a letter. I'm going to get a letter one of these days that says, Fran, I demand the association cut down a tree because it's blocking her solar panel, blah, blah, blah. You're hurting my person. So yeah, I get it, Janet. Al says again, Al's into this stuff. Go, Al. You had your coffee this morning. Um, when setting guidelines, please have knowledgeable individuals setting them. Yeah. So Al's point is well taken, right? I don't really know anything about electricity, so as other than being a condo lawyer, and that qualifies me in no sense whatsoever. And so, yes, the guidelines should be set by an electrician or an engineer that knows this type of work. Um, Otherwise, they you risk incurring more liability, right? Because you set specifications, people obviously will assume they are good specifications. And when the fire happens or the thing falls off the balcony because it's not attached right, um, they're going to come after you too. Um, let's see, Anna says, I was thinking about our engineering firm to set specifications for sure. Yeah, the engineering firms, same thing, can set specifications. But keep in mind, many engineering firms are multi-discipline firms, but make sure you get a person who knows stuff about electricity. Not all engineers, believe it or not, know a lot about electricity. So sometimes electricians are way more well versed in that. So make sure you speak to somebody who knows what they're talking about. How different from satellite dishes being installed on the roofs? So Janet, it's it's different in that the satellite dishes were not bringing anything into the association system from an electrical standpoint, to my knowledge. It was just bringing in a signal, like a video and sound signal. This is a little different in terms of electricity. As I showed you in the picture of those panels, um, actually, it seems to me that there's a greater chance that those panels are going to go flying. I could be wrong. I mean, satellite dishes are heavier, probably than these panels, but from a wind profile, they seem a little bit like a sail to me. So not a lot different, a lot of similarities in terms of liability, in terms of wiring and punching holes through things, but you're actually bringing electricity in, and to the extent there is any fire risk. I think that profile is a little different than the antenna. Um, Wayne says, "Hey, the reason for the requirement that they not feed back into the main electrical system is a power failure is for the safety of the lineman." Okay, yeah, that makes a lot of sense. Thanks, Wayne, wherever you are. Hey, Wayne. Uh, my That's great. I should know that. So my dad, who's still alive, although he's in a nursing home, he was a real lineman, right? A real lineman for Pico, Philadelphia Electric Company, back in the day. He will remind you of this anytime you see him. I don't know why, but before bucket trucks before bucket trucks. Do you understand what I did, Fran McGovern? I had to climb with hooks in a wooden pole and a leather strap belt to the top of an electrical pole in the middle of a crazy storm and not kill myself with electricity. So my father reminds me of that all of the time. But Wayne is right, right? You don't want to blast a guy or a woman off a pole even if he or she is in today's world in a bucket truck, um, by having power running through lines that everyone in the world thinks are not powered, right? So thanks, Wayne, for that. That makes a lot of sense, right? That's a real wake up call, right? You get up there and you blow up a transformer in your face or something. Not good. Let's see, who is this? Mike says, so request this go through ARC and the committees. Yeah, I think so, Mike. I think you talk to ARC and the committees, and like I said, get a professional on the line. Maybe Wayne, I don't know. I don't know your whole background, Wayne. So maybe maybe Wayne just founded a consulting company, and him and Al can have second careers together. But so yes, whether it's Wayne or Al or somebody who actually knows what they're doing in terms of the electrical issues, the wiring issues, and so forth. Make sure you get somebody who knows what they're doing, and run it through your associations. If it's your ARC committee, great. If it's one of the other committees, great. If it's the board itself, great. But just get ahead of this. And this is good. This is good that we're all talking about it today. That's one of the reasons why I do these first Fridays with Fran. Number one, you know, um, it keeps me on my toes as a professional in this industry, right? So I have to keep learning stuff every month. I have to try and keep learning stuff and stay on top of it, which is great. It forces me to learn, but it also helps all of us get ahead of these issues as they come out. Um, Ray Barton says quick math. At 25 cents a kilowatt, the 1200 watt would provide less than $30 a month in savings, $360 a year. The HOA should build cost savings sheet that might discourage the use of the unit. Huh. All right, so I hear that, Ray. So Ray's putting some math on it. So that's a cost benefit analysis. I don't, you know, I think Ray's probably got the numbers down better than I do. Um, right. So what is the value of spending $2,500 if it's saving you 30? So what is your break even, right? Like what is your time horizon on break even for spending $1,000? I don't know, but I guess what Ray is suggesting, if the association could do something um, that could highlight the cost benefit, people may say, hey, you know what, this just doesn't make sense. Maybe. I don't know. I guess it depends how expensive electricity gets. And it also depends on what these systems cost, you know. Uh, Charlene says, thanks, that's great. Could an HOA require specific liability insurance? So I think, John, based on the ability to require that the unit owner or tenant indemnify, I think it's a reasonable interpretation to say that that has to be backed up by insurance, right? However, that's not the letter of the statute. So you might wind up in court on that, right? And because some judge is going to have to make a determination whether that also suggests that the association can require insurance. Um, so that's the issue there. The act does not say specifically that you can require proof of insurance. Ellen Kaminsky says, "Are you saying I'm old? Are you saying I'm old, Ellen? I didn't say anyone was old. I said we were the same age." In fact, you know, yesterday I was at a meeting with another attorney that was similar in age to me, and he had like that. He looked really good. He had that. You know, you comb in the color stuff going on. And I was asking my staff when I came back, should I start with like combing out the gray, washing out the gray? I don't know. We'll see. I haven't tried it yet, but maybe one of these days I'll jump on and I'll have like a full head of, you know, wavy brown hair again. I don't think so. But but yes, I'm not saying you're old, Ellen. I'm sure you know, I keep telling myself we are young, we're doing fine, right? Alba says if backs of homes are on a golf course and current governing documents state that any damage to windows by golfers are between the homeowner and the golfer, would wording need to be changed to also include these panels? I mean, you could do it, Alba. I think that, you know, so I've written articles on the liability of golf course damage, not in a while. That is a kind of very specific issue. So I think you would have to address that in your case with me, and we have to talk more about that because that plays into homeowners insurance as well, whether it's the golfer's homeowners insurance or the homeowner's homeowner insurance. But you know, it's damage in either case, right? So you know, golfers, I've seen golf balls go right through vinyl siding. You know, so it's not just windows, just goes bloop right through vinyl siding. And I've seen them smash skylights. I've seen them smash windows. And I'm not a golfer, and that's probably why I know so much about the damaging houses, because I do play best ball tournaments sometime. So that's a specific issue, and I think if you want to cover it and you have rules and regulations, I would say add it. Sure. Um, Early in my telco career, I spent many hours on hooks like your dad. Okay, that's great. I assume your hips and knees have been replaced by now then. So Wayne says he's been up to, you know, hook and belts too. That's great. Al says he hated gaffing too. Candace says, would the HOA then have to grant permission for outside plugs for these? You know, so that may be the answer, Candace. Whether you can wire it through you actually have an outlet on your patio and plug it in that way. Many patios I see don't have outlets, but I guess that's an answer, right? Just require an exterior outlet with a cover, and then it just plugs in there. I think that's a more manageable way than some knucklehead just taking a bit and driving it through your wall for sure. So that sounds like one solution, but again, I would talk to your engineer or your electrician. Uh, that seems like a decent suggestion, though. Barb says, "What should ARC use as the basis for planning guidelines? Is a copy of the bill? Is there a copy of the bill that we could have?" Yeah. So, Crystal, I have a copy of the bill, and we could just send it out to everyone on the call, the link for it. Um, Ray says bald is beautiful. I'm with you, Ray. I'm on my way. I'm trying to get there. It's getting thinner every day. So uh, it's great to see everyone. I think that's it. If we have no other questions, that's it. Um, so we'll be seeing these soon, and you will be seeing solicitors, right? So anticipate solicitors, anticipate applications for these things, and anticipate people putting them in without permission. And if you do see them being put in without permission, you check it out, especially in mid rises and high rises, because you don't want things flying off the building and hurting people. But it's great to see everyone. I will see you in August. Have a great summer. Please hit the beach or hit the mountains or hit the lakes. Great to see everyone, and thanks so much for attending. See you soon. Bye bye.